3, 2, 1, start. It is submitted by the learned advocate for plaintiff. It is submitted by the learned counsel for the accused. It is submitted by the learned counsel for the defendant. It is submitted by the learned counsel for the opponent. It is submitted by the learned counsel for the petitioner. It is submitted by the learned counsel for the plaintiff. It is the case of the defendant. It is the case of the prosecution. It is the contention. It is the contention of the learned advocate for the accused. It is the contention of the learned advocate for the defendant. It is the contention of the learned advocate for the plaintiff. It is the contention of the learned counsel for the accused appellate. It is the contention of the learned counsel for the defendant. It is the contention of the learned counsel for the petitioner. It is the contention of the learned counsel for the plaintiff. It is the contention of the learned counsel for the respondent. It is the next contention of the learned advocate for the accused. It is the next contention of the learned advocate for the defendant. It is the next contention of the learned counsel for the accused. It is the next contention of the learned counsel for the defendant. It is unsafe to convict. It is unsafe to rely. It is unsafe to rely on the evidence of. It is urged. It is urged by the learned advocate for the accused. It is urged by the learned advocate for the defendant. It is urged by the learned advocate for the plaintiff. It is urged by the learned counsel advocate for the respondent. It is urged by the learned counsel for the accused. It is urged by the learned counsel for the defendant. It is urged by the learned counsel for the petitioner. It is urged by the learned counsel for the plaintiff. It is urged by the learned counsel for the respondent. It is well established law. It is your duty. It must appear. It must be. It should go to show. It was contended. It was held. It was urged by the learned counsel for the defense. It would go to show. Joint family property, joint Hindu family, joint possession, jointly and severally, judge of the facts, judge of the high court, judge of the law, judge of the lower court, judge of the Supreme Court, judgment creditor, judgment debtor, judgment file, judgment of the court, judicial function, judicial magistrate second class, judicial officer, judicial opinion, judicial probe, judicial process, judicial separation, jump bail, juris number, jurisdiction of the case, juris charge, jury instructions, just state to jury, just state venue, justice of peace, juvenile court, juvenile delinquent, juvenile detention, juvenile matters, juvenile offender, juvenile probation, Karnataka Rent Control Act, Calcutta High Court, lack of evidence, land acquisition officer, land mortgage, Land Reforms Act, last will and testament, law courts, law journal, law of crime, law of estoppel, law of inheritance, law of limitation, lawsuit, law unto oneself, law abiding, lawful possession, lawyer's notice, lay down the law, lending question, learned advocate appearing for the accused, learned advocate appearing for the accused argued, learned advocate appearing for the defendant, learned advocate appearing for the defendant argued, learned advocate appearing for the plaintiff, learned advocate for the accused argued, learned advocate for the complainant, learned advocate for the defendant, learned advocate for the defendant argued, learned advocate for the offender, learned advocate for the plaintiff, learned advocate for the plaintiff argued, learned assistant public prosecutor, learned counsel appearing for the accused, learned counsel appearing for the accused argued, learned counsel appearing for the defendant, learned counsel appearing for the defendant argued, learned counsel appearing for the petitioner, learned counsel appearing for the plaintiff, learned counsel for the accused, learned counsel for the accused appellate, learned counsel for the accused argued, learned counsel for the accused argued before me, learned counsel for the defense, learned counsel for the defendant, learned counsel for the defendant argued, learned counsel for the first plaintiff, learned counsel for the first respondent, learned counsel for the petitioner, learned counsel for the plaintiff, learned counsel for the plaintiff argued, learned counsel for the respondent, learned counsel for the second respondent, learned friend, learned judge below, learned judge of the high court, learned judge of the lower court, learned magistrate, learned munsif, learned munsif magistrate, learned prosecution argued, learned public prosecutor, lease contract, leasehold property, least bit of evidence, legal action, legal advisor, legal age, legal aid or legal service, legal assistance, legal charge, legal custody, legal department, legal domicile, legal fees, legal proceedings, legal representative, legal separation, lessee tenant, lessor or lessee, let go. Let me discuss in brief. Let me discuss in brief the evidence. Let us see. Letter of intent. Letter of the law. Liability in contract. Lien creditor. Limitation period. Lease pendants. Locus standi. Lodge a complaint. Look at exhibit. Look through. Look through. Lower court has erred. Lurk in house trespass. Magistrate. Malicious prosecution. Malicious security proceedings. Mandatory injunction. Mandatory provisions. Manslaughter in the first degree. Manslaughter in the second degree. Many witness. Marked subject to object. Marked subject to proof. Material fact of the case. Matter of record. May be considered. May I take the opportunity. May it have been. May it not have been. May rendered. May there have been. May there not have been. Medical certificate. Medical college hospital. Medical evidence. Medical jurisprudence. Medical officer. Member of the unlawful assembly. Memorandum of appeal. Memorandum of association. Memorandum of transferor. Mesme profits. Myths and bonds. Might there have been. Mineral rights. Minimum Wages Act. Mischief by fire. Mischief of killing. Misconception of fact. Misjoinder of case of action. Misjoinder of charges. Misjoinder of facts. Misjoinder of parties. Misreading of a document. Misrepresentation of fact. Mistake of fact. Mistake of law. Mitaxara conspiracy. Mitaxara coercionary state. Mitaxara law. Mitigating circumstances. Mitimus judgment. Modus medical jurisprudence. Modus operandi. Mohammedan law. Moral turpitude. Mortgager and mortgagee. Motor Vehicle Act. Motor Vehicles Taxation. Movable and immovable property. Movable and immovables. Movable property. Multiple wounds. Municipal Commissioner. Municipal Council. Murder in the first degree. murder in the second degree, must be considered, must rendered, mutantis mudandis, my best recollection, my learned procedures and procedures, my recollection of the accident, my recollection of the conversation, my recollection of the testimony, my remarks, my remarkables of the event, my reimbursement, my reimburse of the event, my reply, neglect of the defendant, neglect minor, negligence of the defendant, negligence of the driver, negligence conduct, negotiable instruments act, next argued, next contention, next of kin, next point for consideration, no contact order, no contest, no evidence is adduced, no evidence is forthcoming, no fault diverse, no order as to costs, non-ayacut lands, non-bailable offence, non-bailable warrant, non-financial bonds, non-testament instrument, notary public, notice of sale, null and void, objection overruled, objection sustained, of my own personal knowledge, of my own knowledge, of one own free will, of such assembly, of the record, offensive weapon, office copy of the letter, office copy of the notice, office assignee, office liquidator, office receiver, on condition that, on conditional, on consideration of the evidence, on one occasion, on one side, on or after, on or before, on probation, on record, on the contrary, on the date of incident, on the date of occurrence, on the date of offense, on the fact and circumstances of the case, on the one hand, on the other hand, on the other side, on the same day and time, on this side, on what side, on your direct examination, once in a while, once or twice, open, close, opposition direction, or in the alternative, order of detention, order of inheritance, order to detain, order to be destroyed, order to be returned, order of temporary custody, out on bail, out on parole, partial agreement, partition and separate position, partnership deed, patent holder, patent office, patent pending, pecuniary interest of government, pedant light, penal provision, penalty clause, pending inquiry, per procuration, peremptory orders, permanent injunction, persuasively admitted, persuasively argued, persuasively urged, placing the evidence pros and cons, planned schedule house, planned schedule land, planned schedule mansion, planned schedule property, planned schedule street, plausible explanation, plea bargain, please state whether or not, point for consideration, point for determination, point for consideration, point for determination, police officer, police station, possession and enjoyment of the house, possession and enjoyment of the land,